On this day in history, May 31st, 1790, the United States enacts its first copyright statute, the Copyright Act of 1790. Included in the following is an excerpt from the 1944 edition of the Encyclopedia Britannica going over copyright within the United States. The protection of copyright by statute in the United States began with the enactment by the state of Connecticut in January 1783 and by the state of Massachusetts in March of the same year, of acts which gave copyright for a term of 14 years, with the right of a 14-year renewal if the authors were living at the expiration of the first term. This action was a result of a vigorous crusade by Noah Webster. Before May 1786, 10 more states had passed copyright acts for varying terms. These acts followed in principle and substantially in form the English statute of 1710, known as the Act of Queen Anne. Prior to the organization of the states in 1783, what protection had been enjoyed in America by authors had to be secured in the colonies, as in Great Britain under the principles of common law. In 1790, the U.S. Congress, influenced in large by the arguments of Noah Webster and other literary workers, enacted the first national statute. This act gave to authors who were citizens or residents, and to their heirs and assigns, copyright protection for books, maps, and charts for a term of 14 years, with the right to renewal for 14 years more at the expiration of that time. The statute provided for the deposit before publication of a printed title page in the clerk's office of the local U.S. District Court. It provided further for the advertising of the book, with specification of the copyright entry 4 times within the first 2 months after publication. Requirement was made for the deposit within 6 months of publication of a copy of the book with the U.S. Secretary of State. The penalties imposed upon a printer of an unauthorized impression of the book so copyrighted included the forfeiture of his piratical copies and a fine of 50 cents for each sheet that was found. Half of this fine went to the owner of the copyright and half to the United States. The statute also made provision, in confirmation of rights existing under common law, against the unauthorized publication of manuscripts. This original act was followed by the Act of 1802, which required the record of copyright to be printed on or following the title page. The same requirement was made for designs, engravings, and etchings entered for copyright. The statute of 1819 gave the U.S. Circuit Courts original jurisdiction in cases of copyright. The Acts of 1831, which was, in substance, a consolidation of the previous acts, included a provision for the protection of musical compositions. The term was extended to 28 years, with renewal for 14 years to the author, his widow, or his children. The requirement of newspaper notice, except in the case of renewals, was cancelled. This statute confirmed the requirement for the deposit of a copy with the U.S. District Clerk. This copy to be transmitted to the Secretary of State within 3 months after publication. The Act of 1834 required that record in the court of original entry should be made of any assignment of the copyright. In 1846, the Smithsonian Institute was established by Act of Congress, this act making provision for the delivery of 1 copy of a book securing copyright to the library of this institution. The same act provided for the delivery of 1 copy of the copyrighted book to the Library of Congress. This was important because depositing and cataloging these books in the Library of Congress, a requirement confirmed in all subsequent acts, made it practicable after 1846 to secure prompt and trustworthy information from the library and, in later years, from the bureaus of copyright connected with the library as to the status of the copyright of any literary work. The publication desiring to ascertain whether or not a book is in the public domain or who is the recorded owner of the copyright made application under the Act of 1846 to the Librarian of Congress, and since the establishment of the Bureau of Copyright makes application to the Register of the Bureau and secures for a fee of $1 the information required. The opportunity of ascertaining the precise status of literary productions, which has been entered for copyright, is of assured convenience and importance to the publishers and to the book-buying public. The U.S. Act of 1856 secured to dramatists the protection for the right of performance. The Act of 1859 made the Interior Department, instead of the State Department, the custodian of copyright. The Act of 1861 provided for an appeal to the Supreme Court in all copyright cases, irrespective of the estimated value of the property in question. For other than copyright appeals, it is required that the property in question shall have value of not less than $5,000. The Act of 1865 again placed under the control of the Library of Congress the copies of books deposited in connection with the entry of copyright. The deposit had to be made within 1 month from publication. The provision covers not only books, but works of art, photographs, and negatives. An amendment in 1867 provided for a penalty of $25 in the case of failure to deposit within the month specified. 12 acts having to do with copyright had become law prior to 1870. That year brought a general act which provided protection not only for works of literature, but for paintings, drawings, statues, chromos, models, or designs, and superseded previous statutes. This act canceled the control by the local district courts of the system of registry, and made the Librarian of Congress the copyright officer. It was required that the printed title page of the book be filed in his office before publication, and 2 copies deposited within 10 days after publication. The application of copyright law, unlike that regarding patents, is solely a question for the courts. The Librarian of Congress is simply an officer of record and makes no decisions. In 1874, an amendatory act made legal a short form of record, copyright 18-by-AB, and the protection of the label designs was transferred to the Patent Office. In 1879, the appropriation bill of the U.S. Post Office contained a provision prohibiting the transmission of any publication that violated copyright. In 1891, after a campaign extending over many years, a copyright measure providing international copyright became law. The first attempt to bring about international copyright had been made by a committee instituted in 1837 by George P. Putnam, who all his life worked actively for the establishment of copyright relations between the United States and the other literature-producing nations of the world.